am going live. Welcome to the show tonight, Pro Se Legal School. We provide the tools, and you guys do the work. So you guys probably know we got a situation going on over here with the divorce court, Miss whatever the hell her name was. I hate to call them a judge when they're over here screwing people over. And so they got the hit squad that's here. I don't know. I think maybe they came to get her. oh. Okay, but when the corporation's getting ready to try to shut you down, because this ain't the first time that they came around her. If I remember correctly, it's been 2 or 3 times. I don't know. It's been a while since they tried to get up in my face. But anyway, so when they come in, the first thing they need to do is file their notice of appearance because they're foreign agents and they have to file this notice of appearance because they're a foreign agent. And then, and then, and then, and then, I'm getting to it, Heather. Just slow down just for a second. I'm getting to it. And then they're here to investigate the complaints from the corporation, because corporations are the ones that complain about me and my business or whatever. And so they're here to address the corporation's complaint. But that's not what they tell people. What they tell people is that they're here to investigate under the Consumer Protection Agency. They assume they have the authority to investigate. And they do. Corporations. I'm not a damn corporation. They ain't got no authority to be in my face about shit. I mean, anything. So, but that's what their job is. So they come in and they do the notice of appearance, and then they start their investigation. Their investigation, Heather, is into anything that they can use to shut you down or to make you go sit down and shut up. And when they can't make you do that, then they pay snitches to lie on you. And this is where the snitching part comes in. Now, this happened before, but they didn't pay the snitches because in this case, there was no snitches. This happened before in a credit card lawsuit that I was helping a friend of mine that I work with. Yeah, and I think his bill was like $165,000 with Discover, and we crushed it. And, well, it wasn't really with Discover. It was with the damn attorney that was acting as a third-party debt collector who bought the illegal. Okay, we didn't get into that. Yeah, and so what happened was that the last time they tried to shut me down, the attorney gave them the paperwork that my friend used to crush their ass, and told Miss Lynette Baker, who at the time was the assistant attorney general that they hired to come after me. She didn't have a bunch of flunkies like these people. They sent 3 people this time. I'm scared. Yeah, and so she dragged me into court, and she used that lawsuit that my friend used to crush the collectors with to prove to court that I was injuring people. They're real sloppy. They're real sloppy with how they do stuff. So, so when I actually got a copy of the stuff and looked at it, like, so I called my friend, and he's like dying laughing. And he's so grateful that he had to pay the collector stuff because they already charged that shit off the insurance. They wrote it off the taxes or whatever. And they got the money from your ass from the fake program that they set up for you. So anyway, so I was pretty pissed that that's all he had. So I wrote a bunch of motions, and I actually called the assistant attorney general and left a bunch of long messages about how they better have that investigator in there that showed up without it, because he ain't investigating nothing. Now, my friend gave me a power of attorney, or not power of attorney, but an affidavit, saying that, that he used that to stop. Yeah, so when we got to court, the investigator was over there sweating bricks. I mean, he was sweating bricks. Luckily for everybody, I had my grandkids with me. They were 7 and 8 years old, so, I had to be kind of nice. I had to keep my mouth kind of shut because I wasn't willing to go to jail that day. But anyway, they went and sat their happy asses down. So the next thing they have to do is investigation. And during their investigation, that's when they run around and talk a bunch of crap and try to pay people to do whatever. But, we're a little more educated right now, so we just chopped them off, had to chop their legs off with the chopper. With the demand to strike, we struck in their notice of appearances from the record, and we added them to the program. So we'll see what they got to say now. I think they'll find out it don't matter. They send 6 or 8 of them, and it don't matter. Because, number one, they're all paid by the state, which is the same corporation that we've added to the, and we added the Bar Association too, and we added, so the state can't represent people that's already being paid by the corporation, and the corporation, okay, well, you know what, let's just make it easy because it's getting too damn complicated right now. So we're just gonna make it a little easy. So the problem is they can't answer to the document that we filed in state court to crush the state court process because we use federal case law in there. Bam! I wonder why they didn't think to do that with you people. Yeah, when you go into, and there's no difference in you than doing that than there is using Supreme Court case law in either one of the lower courts. But here's the problem. Vendessa allá tenemos un problema. They have a problem. The problem is you can't respond, you can't answer to federal case law with state court shit. Because state court crap is statutes and revised statutes and codes. Now, for the longest time, I didn't know what a code was, but I found out the other day. And a code is just the corporation's interpretation of the statute. So you're already getting screwed on the statute because it's not a valid law. It don't have acting clause, titles, or bodies. But then when it comes down to the corporation's opportunity to do that, yeah, they do a check down. Yeah, and that's why we don't use any of that stuff. Okay, but so today we're here to talk about LA, I'm talking about the snitches that the government use when they need to get something done. They pay people that are already in trouble and arrested for other stuff. They give them the deal. They offer me a deal. They want me to lie on my wife, on my wife's girlfriend. It wasn't a very good deal. They did tell me they was going to let me keep my house. They would let me out of jail that day, and I wouldn't have to go back to the mental institution for forced medication if I took the deal. And they would let me keep my house. I guess they think living in a house by yourself is a lot of it's a lot of fun. No. I told them, yo no quiero ver mi casa ahorita porque me gusta la comida aquí en La Pinta. That means I told them I wasn't in a hurry to leave because I like the food. Then they sent me back with forced medication order. So that was kind of rough. But here's the deal. Oh, hey, William. I need to stay focused. Yep, snitches. Snitches. Chismosos. Yeah, they're very generous. Yep, that's why I like the food there. So you guys probably heard me talking about my girlfriend, my wife. Now she's my girlfriend when she came back and started ready to kick these people in the face about what they're doing to her, what they did to her, and or still doing, because she found out that they were taking her. They had another tax lien on her after she spent, I don't know, 6 or 7 years over in federal camp over all they had on her that was $1,400. Okay, but in trial it was hundreds of thousands and tens of thousands or whatever, and that $1,400 was somebody else's crap that her attorney didn't. John Duma is a piece of crap, and he didn't do anything to. Okay, so she found out there was a lien against her still 5 or 6 years after she got out. And it was blocking her from investing on the platform for investors, blocking her from property purchase. It was So yeah, so she decided she had enough of that. That sounded like my girlfriend's back. So the prosecutor Tara D. Moorhead and Marietta Parker have gotten themselves, all of the crap that we said was true for years came to the surface, and a bunch of people have spent. One guy spent 23 years locked up in jail because of Tara Moorhead's lies. And that's, yeah. Anyway, so we decided we're going to do something about that. But, we had to figure out how to add new evidence, how to open the door with new evidence. I mean, I already had other ways to open the door, but, we're going to, Oh, yeah, we found the firebomb, and I'm going to share that with y'all tonight. Yep, so we started out under Rule 60B, offering new evidence. Well, I didn't like that because that's a statute. Statutes and codes are not valid laws. And they've been, studying my stuff. They know that I know that. And I know they got no problem using it to smash me, but they ain't going to recognize it on the other side. So I decided I wanted to have something a little bit tougher than that because I like to have fire come out, So we got started doing some research. And what I found, and I'm going to tell you all this, I'm going to copy and paste this in the thingy. Oh, this is so badass. Fraudulent concealment. Has anybody heard of that before? Fraudulent concealment. And so the Supreme Court has stated that, and that right there that I posted is fraudulent concealment is a common law doctrine. It's a federal common law matter, and that actually was put on the books. The Supreme Court adopted it in 1874. And so the Supreme Court stated that the law recognizes that people who commit fraud should not benefit from their conduct. So when a defendant engages in fraudulent concealment, the statute of limitations is told, it's stopped, it's ended, it's over. Now, I don't know if y'all think like I think, but this is huge right here. Because not only can you take your ass back in the door, it don't matter how long ago it was. I don't care what it was. And someone help me here. If I got this twisted. Fraudulent concealment. Everything they do is fraudulently concealed either in administrative court or jamming your butt up with statutes and codes or non-valid laws, coming at you for criminal statutes that are not valid laws, federal criminal statutes are not valid laws either. If you don't injure anybody or damage anybody's property, no. Oh, I'm really freaking excited about this. Fraudulent concealment occurs when a party intentionally hides, suppresses, or material fact that they are legally obligated to disclose with the intent of deceiving the other party. Oh. Now, you guys know that I have ADD head, and so when I get this stuff, and especially when I get fire out the hole like this, I'm already thinking like all these different ways. All these different ways to use it. Okay, so here are the elements, the key elements required to establish the case of fraudulent concealment. Concealment of material facts. The defendant must have concealment or suppress material facts, a duty to disclose. Defendants must have obligated to disclose the facts to the plaintiff's intent to defraud. The defendant must have intentionally concealed or suppressed the facts with the intent to defraud the plaintiff. And this is one that a lot of people leave out, but we don't. Well, the next two. Their reliance. The plaintiffs must have relied on the absence of the concealed fact. And the other one is damages. Plaintiffs must have suffered damages as a result of the concealment. Now, the elements are, how could I put this? The elements are the way that you have to write it up. You know, if you're going to write it up, and you can do your homework on this. I wouldn't rely on the first things you find. Would not rely on the first things you find. But if you do your homework on this, you learn these facts, and then you want to write. You want to put your facts around this, or I would have this as probably before I got to the 42 USC and all that stuff, because this is huge right here. And if they didn't have it set up to where it tolls, it allows the stuff to roll. So we talking about fraudulent concealment here. These are for the people. This sounds like an attorney question, okay? Okay, you can start where I'm at the gate, or you can start in the middle of all that crap where you're at right now. And when you start in the middle of that crap, you might as well just kiss your ass goodbye. I'm just saying. Fraudulent concealment. Now, you have to write this into your document. And when you review the elements and you research it, then you should be able to figure out how to add that into your documents and your summary. Now, for those of you who think this is really complicated, and I'm going to share this with you. I went over to the Copilot, and, I'm thinking, if this is powerful enough to make the Supreme Court say that it don't matter how long it's been, if you can prove that they fraudulently concealed that stuff, then it's a wrap, and you get to sue their ass. So I'm like, well, how about if we use it to dismiss some shit? Oh, okay, I'm starting small, okay? And then I'm like, well, I wonder if you can sue them and use this as a cause of action. Oh, that would be so much simpler than trying to do all this other stuff that I've been that I've been talking about. Okay, so I'm just gonna throw it out there, and share some of my secrets. So I was like, I wonder if you can use this as a cause of action. So I asked the co-pilot, the AI shit up there, but you gotta be real slick about how you talk to the AI shit, okay? Because if you talk to the AI shit to crush attorneys' asses, it's gonna tell your ass to go get it. No. Okay, but if you work with it for a while, you figure it out. So I just asked the AI to print me a civil claim for fraudulent concealment. I knew it was not going to have. I was hoping that it would come up with an outline or something, And well, for those of you who haven't done it yet, it came up with an outline for the lawsuit. I know, that one didn't go through. It might have too much stuff in it. Yeah, so that's just, there it went. They're just, now you can get the outline for the lawsuit or one of mine or whatever, but this is pretty cool here. It has the outline. This is the only part of it. It's pretty long, so I can't post the whole thing in there, but it already told you how to find it. And if you want to do that, I'm looking at that. Oh, that's so much. Yeah, it's one of the projects that I have. But right now, I'm learning how to write this up and insert it into my wife's document that her and my girlfriend are going to file next week. And then once I do that and get that project done, then I'm going to add it to the premium packages. And so that's how they go. But I'm teaching everybody how to do it so y'all can add it yourself. Oh no, Roger. I don't. I use it. I have the outline here. I have the outline of how to do it. No, I don't use it for case law or none of that shit. I don't. I don't use their case law unless I'm jamming their ass up with it because I'm not obligated to follow that shit. I'm not a U.S. citizen. I'm not obligated to follow statutes and codes or none of that shit. So I appreciate it. But I already know if you write up a whole thing from this, it's going to be stupid because it's not going to tell you what you need to know to kick their ass right out the gate if you ask it out straight. So, and I'm not real good at jamming. But at the end of the day, there's also, does it make sense? Does it fit into what I already know? Those are all the things that I consider, even when I'm doing research on the internet. Because I found out unless you go several pages back and sometimes further, depending on the touchiness, the sensitivity of the situation, you're going to find what they want you to read. Most people will look at that, Cornell Law Library, yeah, or they go to attorneys' websites, Now, attorneys' websites do have information, but not enough to help someone who don't know shit. I'm just saying, not enough to help you if you don't know what the hell, if you're like, yeah. So you want to keep that in mind. Now, this is pretty powerful, and people can, what I suggest is to use the words. call their ass on the phone and use the words. You know, my legal team said you guys are guilty of fraudulent concealment, and I could bring this up anytime in 125 years. Oh, fraudulent concealment. Did you know the bar to prove fraudulent concealment is a whole lot lower than trying to prove mortgage fraud, foreclosure fraud, or due process violations, or any of those things that are what people use in the conventional program. Yeah, dude, I would be making a list, a script, a listed script, a list of scripts. Yep, to read in the phone and call these people 3 or 4 times a week. And, you know, after they get your number, they'll tag it, so you'll go straight to voicemail. And then you fill the voicemail up, asking them for stuff that's in the lawsuit package. Let them know your legal team said this. My legal team, we don't know this shit because we're stupid. So you got to leave that shit on the legal team. And it's a good way to mess with their head. I like teaching people how to do that because now they have to think. They know somebody put this, because they was beating your ass yesterday, okay? They know somebody put this shit together for you. But it protects you on the backside, okay? Because they know that the shit is going to keep getting shoved in their face, even if you're not here, because the legal team is the one that's doing it. In the end, then they'll know who set their ass on fire. So this is something you guys can use, people that are doing this yourself. And I'd start out using it on the phone. I'd call them. I need to talk to the judge. I'm not lying. I need to talk to the judge about fraudulent concealment. You know, I think you're all guilty of that because the judge is pretending to be in a judicial court and he's in an administrative court. And y'all, y'all committed real estate defraud to get money. Yeah. Okay. I could go on for a while. Thank you guys for the value of sharing your time. I'll see you guys. In the next video. I'm going to post a video tomorrow. It's kind of an update on what, the hitmen that are coming for me. Hey, Tammy, what's up? Now, at the top of the show here, and you know what? I just go ahead and post it again. I posted the information, so you guys can contact the Attorney General because they got the investigators down here. And I'm sure they're gonna be looking in for snitches, but they don't have to pay y'all. Y'all can call them up and tell them the truth on how we roll over here. I ain't worried about them. I already chopped off the legs of the first 3 that showed up with the demand to strike. And Tammy, since in the divorce case situation, since they brought in, the judge recused herself and went and sat the hell down, and then they have some other people running the show now, and they brought in like 3 people from the Attorney General's office. So we went ahead now and chopped their legs off with the demand to strike, and then we're going ahead with temporary restraining orders filed, and you got that done last week. And so there's a couple more documents I made. I have a demand to default. We're going to jam that in their face as the last thing, and I don't have it right here. So my kid went down to get one of the things I told him to do when he's filing this other stuff, just sticking in their face, was to get a file stamp copy of his lawsuit, even from the state court level, or a certified copy. A certified copy of his lawsuit so that we can use it for the less pendants situation, because we want to file less pendants on the judge's property that has a bunch of a bunch of law firms in it. This is going to be so much fun. And he came back and he didn't get He didn't get a certified copy of the lawsuit. He got this big old thick thing that's this thick. Yeah, it's a certified copy of the complete docket. I was like, what? He's like, did I do good? Dude. So we have a certified copy of the complete docket. Now, missing out of the docket is the process of service paperwork, which is what we argued in our stuff in the first place in their divorce case, counterclaim that we filed in their divorce case. And we actually had an employee there. I don't want to say who. We had an employee there looking at the file a while back, and told my foster kid, dude, I'm gonna print off everything that's in the file. Everything that's in the file, I'm gonna print it off for you. Because he didn't know what was going on. So she printed off everything that was in the file that she was looking at. Or was it a he? Or was it the computer? Anyway, and all he got was the journal entry. That was all that the employee was looking at. It was the journal entry that was entered a week or so ago. It didn't have any paperwork or any, but they didn't know that we knew that. And so now when the people came in here from the Attorney General's office, all of a sudden, when we asked for we got a certified copy of the complete docket sheet, all brand new stuff. They just printed off a bunch of shit regular. Okay, how do you know that? Because I read, the thing's that thick. I read every single page. Now, most of that stuff that we file. Yeah, but there was documents in there saying, we're just continuing with the orders that are in place. And like there had been some decisions made already. Well, no, they didn't get a chance to get their foot on our side of the gate. And we ain't stepping over there because it's a little stinky over there. But they have these documents in here saying that, that's really here nor there, because they lied, and on the summons, they wrote a different town under the address where my kid, and he was saying, they wrote the wrong shit on it. No, man. Do you remember what you had to do to serve them? Oh, man, there was so much paperwork. Yep. That paperwork comes back. If they really had delivered your shit to the wrong place, then that paperwork would have came back, and they would say he don't live there no more, or I don't know, or something. But I don't know how they could do that, because when they punch that shit in the computer, it'll tell you right away if. But I already knew they were lying. So we're going to use that certified docket as our evidence and just file our case in federal court, because we got the players in state court that are being stupid. And this long they ain't come to the table. Oh, they filed a thing to give them an additional 14 days to answer. I don't know how that's going to help them, because they can't answer to federal court. Case law with state court crap. But don't go that way. So that's going to be a little situation for them. And I'm waiting. I sent them over all of the videos that I made about Joshua Matthews and his $40,000 and $20,000 and whatever $1,000 traffic tickets that he had. Well, they didn't say traffic tickets. I think they're for doing something other than running traffic stuff, But I'm not sure. That's just my opinion. Oh, yeah. Yeah, you gotta be slick about how you do that thing there, cause it ain't gonna tell you straight if you asking the wrong thing, because they're the ones that program that shit, and they're the ones that run the corporations, and that's why we have the problem that we have, and that's why we do what we do. We've learned how to bring criminal liability to the table by adding the Tucker's Act, the Administrative Procedures Act of 1946, the Civil Rights Act of 1871. Now, the Civil Rights of 1871, you want to add if you've been arrested, detained, or whatever, and in addition to 42 U.S.C. 1983. And here's why. I looked that shit up because I wanted to understand the difference. And the difference between the Civil Rights Act of 1871 is that shit is a federal crime to arrest someone without judicial authority or just cause or whatever you want to call it. Okay? Now, and it started when the Ku Klux Klan was around, whatever. So, yeah, so over the years, they changed it. And so 42 U.S.C. 1983 due process was taken from the Civil Rights Act of 1871. Now, what the hell does all that mean? It sounds like a bunch of Okay, here's what it means. They watered that shit down to give us opportunity to regress, but not make it a criminal, a federal law. So I use both if an arrest situation, and then if it's not an arrest situation, then I just use the other one. But I bring the Tucker's Act in there because the Tucker's Act strips their asses of their alleged immunity, and makes it a crime to violate your due process and your Fifth Amendment. And so that's why we had those in front of the 42 U.S.C. 1983. Okay? Now, you have to remember, there's no criminal statutes are bullshit, just like, now, if you injure somebody or damage somebody's property, then your ass on the hook. Okay? But criminal statutes, and there's no such thing as criminal. It's all civil. And they use the acts, the federal acts. Those are federal laws that we're all supposed to be following, but no one uses them because everybody's head stuck in this case law bullshit. In the conventional bullshit. Oh, now we're thinking. I think you better study that first, Heather, so that you understand. Because it ain't what you think. Well, it is, 'cause I just showed you. It's what you think. But you need to understand it, so when you interject that into your lawsuit, your fire, you'll have it. You have it the way you need to have it. Thank you guys for the very sharing your time. I'll see you in the next video, which is going to be tomorrow, so don't miss it. Bam. I got to go see if I think they're knocking on my door. Yeah, well, they got to get their investigation started. I sent them some information and some videos that they can watch so they can get up to speed faster, so they won't have to ask for some more days to answer like they think they can answer to my stuff. All right, bring it.